Guys, this case opens quietly, but every word here matters more than it seems. The court sets the tone, the players are introduced, and beneath the polite formalities, you can already feel tension building that will drive everything later.
Ms. Cannon?
Your Honor, we sent that over to him, and this is juvenile court. What that means is that 3.900 specifically addresses rules related to juvenile court. And the point of that being is that unless there are different rules in juvenile court, and my position is that those rules under civil procedure would not apply. But here's the common sense rule. Okay, I should have gotten it to him earlier. I'm new on the case. Okay, and I'm going to tell you right now, my legal argument is very simple. And my client, see the difference between like the court knows this. My client has constitutional rights. And if the court doesn't want to read my pleading or accept my pleading, I can make I had planned on a 1 to 2 sentence argument anyways. And I don't think if the court prevents that from being accepted or considered, that in a case where my client's fundamental liberty interests are attached at every hearing, that I'm precluded from making an argument against it. And I really didn't have an argument. I mean, that's it. That addresses your specific question, Judge, about how I feel. I will do better in the future for Mr. Blumberg. I've been practicing for more than 20 years. Things happen for lawyers. I'm not one of those people to do that, but I got to accept responsibility for what the court decides. I don't think that the court is going to be, or Mr. Blumberg is going to be prejudiced by my pleading.
Judge, let me just respond because, I've been practicing for 42 years, and while that's a long time, the rules apply equally. This is the third set of attorneys that Ms. Lee has retained in various matters in this case. Every time I get a new pleading, there's another attorney on it, a new attorney. So, the fact that counsel is new to this file, I don't know that explains the tardiness and the prejudice by the filing being received on the day of the hearing. I mean, it's just not good lawyering. It's not appropriate, and it's not fair to my client. So that having been said, Judge, our position is that, and we've filed a motion with a supporting brief that certainly would, on its face, allow Mr. Lee to participate in this case as an intervening party. MCR 2.209A3 allows for the intervention of a party when there is an interest relating to the transaction, which is the subject of the action. What could be more relevant, what could be more important than these children's father being allowed to participate in defending his good name? Because all through this proceeding, prior counsel has been bad-mouthing him, bashing him, making allegations that are not true. I'm not saying Ms. Cannon did it or even Ms. Anderson. Preceding counsel did, and I take offense to that. The fact of the matter is Ms. Lee has been making misrepresentations, false allegations, and I understand the Child Protective Services are currently investigating her for making these false allegations relating to abuse, to child abuse, just to gain advantage, not just in this case, but in the pending divorce case, which a whole nother set of attorneys are representing Ms. Lee. I think my client has a right to be represented in a matter where his kids are at risk. CPS has confirmed and substantiated abuse against Ms. Lee. The fact that they are seeking the return of the children is repugnant to me, but at least allow my client to be heard in these types of proceedings. We think intervention is appropriate, and we'd ask the court to grant our request.
Ms. Cannon, as to the substantive matters, go ahead.
Yes, Your Honor. So I don't disagree that his client has a right to participate. Mr. Blumberg's client has a right to participate in these hearings. I don't disagree that he's a parent, and I don't disagree that he also doesn't have a right for Mr. Blumberg to come to these hearings and appear on his behalf. I'm not going to talk out of both sides of my mouth. What I disagree with is that applying the intervention rule, Your Honor, that's a rule that is not considered or accepted by the juvenile code. We have different requirements under MCR 3.900, and that we even have different discovery requirements. Everything is different. And the reason why I'm making a point, and I don't mean to be on semantics, Judge, but the reason why I'm making a point is because intervention to me is very different than what would be considered his rights to participate. And what I think is that Mr. Blumberg wants to participate in this case on an equal footing with Mr. Sommerfeld and with Ms. Hansel. And what I think about that is that if the court were to allow him to do that it would cause confusion, as you can already see. It would blur the lines and improperly expand his rights. And I don't know that you have to make the decision. I guess from my perspective, maybe these are case by case situation decisions, but look at what already just happened. And that's going to be like the challenge of this case that I'm going to have to like figure out and maneuver for myself. The court is not going to be able to figure out what happened in the front of the court, in the criminal court, and all these other courts. And so my objection is that for me, using the word intervention puts him in the place sort of the petitioner and saying that he has an interest. And what I'm saying is he has an interest in, as a parent, a liberty interest in his children. The court is here in this case to think about whether or not Miss Lee poses a risk of harm to her children, not whether these two have what happened in the custody court and what's true, what's not true. Judge, we're going to be here for 3 years if that's what the court's going to do. So my position is, yes. Does he have a right to participate? Do I think he has the right to intervene? No, I don't think the court rules support that. And I think how much Mr. Bloomberg gets to participate is in the court's discretion.
The mood shifts fast, and courtroom courtesy gives way to friction. What sounds like a technical argument about timing suddenly becomes a credibility fight, with lawyers subtly questioning each other's professionalism and motives. This moment tells you a lot about how hard this case is about to get.
Mr. Sommerfeld, is there any position that you wish to take?
Judge, I filed a short response. I have no objection to Mr. Blumberg's request. I think it's proper here. And for the following reason, the motion to change placement that was filed by previous counsel, it's all an attempt to make Mr. Lee a respondent in questioning the department's judgment as to why he is not on the petition also with Miss Lee. And again, I know that we'll get to that in the other matter, but based upon that, and again, what Mr. Blumberg has said, the things that, and I even put in my first motion about the things being alleged here are wildly inaccurate. They are incomplete. We have partial documents that on the face of things look, pretty horrible. You'd be like, whoa, take a look at that. But then you find out if the rest of the document was there, you would find out there's nothing there. So I think in the interest to protect Mr. Lee's rights, I agree with Ms. Cannon that, that Mr. Blumberg can participate as a non-respondent. There's really no question here, but this has risen above and beyond just because of the personal attacks that are made by Mother's previous counsel and now being argued here, that I think it would be necessary for Mr. Lee to be involved to protect that interest. As to how long that interest needs to be protected, that would be could be up to the court, but I think it's necessary up until that Mr. Lee is not being excoriated in pleadings regarding his, his name, his character, things that he is alleged to have done. So I have no objection to Mr. Blumberg's request for intervention.
All right, thank you. Mr. Blumberg, any final comments that you wish to make on your motion?
No, Judge, I think I've indicated to the court the propriety of my request and the need to have my client's interests protected, not just by Child Protective Services, but by against Miss Lee's attorneys who have historically tried to disparage him and shed him in a light that are not, it just simply isn't accurate. I think all those things have bearing on the ultimate placement of these children.
All right, thank you very much. I would note that the Juvenile and Child Protective Proceeding Court Rule 3.900 and above do allow a non-respondent parent such as Mr. Lee to be involved in child protective proceedings. 3.921B entitles him to notice. 3.924D entitles him to access to case file records as a person having a legitimate interest. 3.963B allows the court to determine whether or not the children should be placed in his custody or care pending the outcome of the neglect and abuse petition. 3.965B entitles Mr. Lee to notification of the preliminary hearing and to be advised that he, as a non-respondent parent, he is entitled to seek placement in his home of the children pending the outcome of this case. So for all of those reasons, I do believe that Mr. Lee's participation and Mr. Blumberg's participation in today's hearing would be appropriate to flesh out and to protect his legitimate interest in the case as a non-respondent parent. I would note that while there is no specific court rule within the 3.9 section that specifically or expressly grants intervention, there are cases that talk about that. I found two, in re CAW 469 Mich 192 from 2003, where the Supreme Court said that a intervention wasn't appropriate under the facts of that case. It was a putative father seeking intervention in a child protective proceeding. They said because there was a legal father, the putative father didn't have standing, but they did not say that intervention was inappropriate. And then the concurring justice, Justice Kelly, cited the then applicable court rule, which is now 3.921, saying that it didn't expressly address it, but did cite the court rule that Mr. Blumberg has cited, 2.201, involving intervention. Similarly, in 2014, the Michigan Supreme Court in re Sanders 495 Mich 394, in a case that decided that the one parent doctrine, that is, you can't use jurisdiction for one parent to bring in the other parent, that was unconstitutional, but it did say that the unadjudicated parent might not be a party in total to the child protective proceedings. And if that's true, then intervention would have been a necessity, or would be a necessity in this case. So for both of those reasons, both the court rule and the two cases, I find that either way I rule, whether it's under the non-respondent father's rights or the intervention court rule, I believe that Mr. Blumberg and his client, Mr. Lee, have a legitimate parental interest. And given the motion that's been filed and that now about to be argued by Ms. Cannon and Mrs. Lee, or Ms. Lee, I believe that his interests do require the ability of counsel to respond to those things. And so I'm going to allow that for today's purposes, and going forward, Mr. Blumberg will be allowed to respond as the non-respondent parent's attorney and will be included as such going forward. So Mr. Blumberg, if you would present at a later time an order granting you that status, I would appreciate that.
I will do that. Thank you.
Thank you. All right, turning now to mother's motion to change placement of the children. That is now being argued by Ms. Cannon or Ms. Anderson, whichever you wish may go ahead at this time. Thank you.
The judge steps in and changes the direction of the case without raising their voice. One ruling here reshapes who gets to speak, who gets heard, and how the rest of the hearing will unfold from this point forward.
I'm sorry, you're on mute, Ms. Cannon.
Story of my life for 6 years now. So, Judge, so is the court going to allow me to present witnesses?
Yes.
Okay. May I make a brief just a brief statement?
Certainly.
Okay. So yes, I do always get nervous when I go somewhere for the first time. Sometimes I get nervous if I go somewhere 100 times. But I do feel that it's important to make a couple of points to the court about this motion that Mr. Kronzak filed. And I think that, first of all, I think the court is within its authority under 3.966 to review placement or at any time. And that specifically on the court rule says that the court must review the placement order or their initial service plan, and the court may modify the order in the plan if it's in the best interest of the child. Also that the court must basically, when having a hearing like this, consider 3.965 B and C, which are actually the court rules that are involved in the preliminary hearing related to contrary welfare to the findings, contrary welfare, substantial risk of harm, and if there's other services and reasonable efforts that could have been provided. Saying this because I think that that is going to be my focus of the hearing today. And I think that might be a little surprising to everyone based on what I've heard already today. I want to point out to the court that one of my concerns after hearing what was said today is that that maybe I won't be the one to bring up all these things, and maybe other people will, and then there's sort of this, Pandora's box that gets opened up, which I can live with. But the point I want to make to the court is that I'm very sensitive to the fact that, child welfare proceedings in terms of pretrial motions and evidentiary hearings, we can't go on for days, like in family court, like in divorce or that kind of thing. And so I was, in preparing for today, seeking brevity. Although my opening doesn't seem like I am, but in terms of what I'm presenting to the court, was for the purposes of seeking brevity, recognizing that probably the court doesn't have 4 Tuesday afternoons to give me between now and trial. I want the court to understand that if I was really, really wanting to present like everything, it would take more than this afternoon. And so what I did is what, you learn to do, which is figure out what you really, really want to bring to the court's attention and hope that you get the court's attention. And that was really the main point that I wanted to make to the court, because I don't want you to think that I'm here to that I don't understand and that there might be gaping holes. I'm really focused on bringing the issues forward today that I think that the court, that are related to the issues that are presented in those rules that I just mentioned. If by some chance things go off kilter, I may have to ask the court to allow me to rebut things. But that remains to be seen. And that's all I really wanted to say to you. I think that I will be able to bring out everything else that I want to say through the testimony of 2 witnesses, which will be Ms. Sullivan and the grandfather in this matter.
I appreciate your attempt at brevity. Let's start with the witnesses.
Okay, Ms. Sullivan, if that's okay.
Ms. Sullivan, do you swear to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
All right.
Okay.
Your witness.
Good afternoon, Ms. Sullivan. I wanted to ask you, how long have you been a CPS worker?
I have been a CPS worker for 4 years.
Okay. And in terms of my client, Renora Lee, and the family of and Mr. Lee and their kids, how many, prior to the instant petition, how many other cases did you have with them?
I had one investigation in January of 2025, which actually resulted in 6 complaints within one investigation. And then I had the investigation in which I removed. So 2 total.
Okay. And then besides you, there were other investigations in 2025. So besides so that would be 7 altogether that or 7 or 8 that you were assigned.
I actually, in my investigation in which I removed, I had 2 investigations within that one. So a total of 8.
Okay. And then subsequent to those investigations, did your office have any further investigations?
Yes, there was an investigation in September of 2024. I had the investigation in January of 2025. There was an investigation in May of 2025. There was one in July of 2025. There was one in August of 2025, and then mine in October of 2025.
Okay. And the investigations prior to October of 2025, were any of those allegations substantiated?
They were not.
Okay. And were any of those complaints against the mother?
Yes.
Okay. When was that one? Was that in May of 2025?
I did not do those investigations. I know the one in August of 2025 was against Renora. But because I didn't do the other ones, I can't adequately answer that question.
Okay. Your office has never substantiated until October of 2025, correct?
Correct.
Okay. And would you agree that that amount of referrals within a 1-year period is a lot, even for your agency?
It is.
Okay. And the majority of those investigations were allegations against Mr. Lee, involved allegations of Mr. Lee, correct?
The conversation turns toward facts, but the details don't come together cleanly. As testimony begins, you can sense the court trying to separate emotion from evidence, while gaps in the timeline start raising unspoken questions that no one fully answers yet.
Correct.
And a majority of them were allegations of physical abuse against Mr. Lee, correct?
Physical abuse and or sexual abuse.
Okay. Now, in terms of the current petition before the court, the major allegation, and correct me if I'm wrong, but the major allegation in this case is that the maternal grandmother, used a spoon to discipline one of the children. Am I correct?
Correct.
Okay. And that your investigation, I'm just saying what your investigation revealed, was that maternal grandmother used a spoon on or about May of 2025 during the time Miss Lee was dealing with another investigation, correct? And that the gist of your petition is that Miss Lee didn't report that her mother had used a spoon, correct?
That was part of it, yes.
Okay. And so in terms of the finding on Miss Lee, what was the actual finding that you made?
Threat and harm of placing a child at unreasonable risk.
Okay. And related, and what was the threat and harm of placing the child at unreasonable risk of harm?
That Renora knew that this abuse was occurring. She did not remove the children from the situation, and that she allowed the grandmother to take the children out of state, knowing that that was happening while the children were in the grandmother's care.
Okay. Now, when you talk about abuse, what made you come to the point of, well, let me strike that. Let me ask you this. You had to do, training to do your job, correct?
Correct.
And in your training, you learn about what abuse is, correct?
Correct.
And is corporal punishment just not allowed at all?
The way that I think.
Well, let me make this easy for you. Are people allowed in the state of Michigan allowed to use corporal punishment with their children?
No.
They're not allowed to use corporal punishment.
No.
People are not allowed to spank.
They can spank as long as they don't leave a mark or a bruise.
Okay.
And if
So,
it's not excessive.
okay. And are you familiar with, and I know you guys, you're not a lawyer, but you are required to know a certain amount of law related to child abuse. Am I correct about that?
Correct.
And do you have any knowledge that people are allowed to paddle in the state of Michigan?
I honestly, I don't know the answer to that.
Okay, fair enough. Moving on, with the maternal grandmother. So specifically, you have this one incident that came to your attention, correct?
Correct.
And I noticed from your documentation that the first person you interviewed about this was Mr. Lee, correct?
Correct.
And when you interviewed Mr. Lee, he provided you with how many pictures did he provide you with?
Maybe 3.
Okay. And can you tell who the child is in the pictures?
You cannot see a face.
And can you tell the date of the pictures?
May 6th of 2025.
Okay. And did you, okay, so with that being said, the grandmother actually was also willingly interviewed with the state police, correct?
Correct.
And she admitted to the state police that she had used a spoon to discipline one child.
I was not present for that interview, so I don't recall if she said one child or multiple children.
Well, you submitted a petition, and that petition you would indicate, is that an accurate petition, or do you need to amend it in any ways?
That it is an accurate petition.
Okay, so in your petition, the allegation is that the grandmother admitted to the trooper that she used a spoon to spank the children. That's an allegation.
Okay, so that would mean that she admitted to spanking more than one child.
Okay, thank you. And that according to your petition, that she denied spanking the children on a bare bottom or causing red marks, correct?
Correct.
So you, under that statement, did you conclude that the maternal grandmother was abusing the children?
Yes.
Okay, based on that, correct?
That was part of it. That was not
Okay.
all of it, but yes,
Okay.
a portion.
But you would agree that's really the biggest thing, correct?
I don't really understand what you're saying. Like
the case came in for physical abuse, correct?
Correct.
And the threatened harm that you found Renora responsible for was the threatened harm of the maternal grandmother's behavior that we just talked about, correct?
Correct.
Okay. So with that being said, did you get any further allegations about the grandmother?
No, I did not.
Okay. Did you have to look her history up?
Yes.
And did she have a history with CPS?
She did have I believe at least one prior CPS complaint that involved physical abuse.
Okay. And what year was that in?
One incident suddenly carries far more weight than anyone expected. What might sound minor outside a courtroom becomes a serious legal issue once it's examined under scrutiny, and you can feel the stakes rise as responsibility and judgment collide.
Oh gosh, I don't remember. It was more than 10 years ago, but I don't remember the date.
Okay. And did you determine that the maternal grandmother was a former foster parent with the department?
Yes, I was aware of that.
Okay. And did you determine that Renora was actually adopted out of foster care by the maternal grandmother?
I was aware of that.
Okay. And in terms of her criminal history, did you have to look at her criminal history?
Yes, I did.
Did she have any criminal convictions for that?
She did not.
Okay. Did you ever interview the grandmother?
I did not. She refused.
Okay. Did you ever look up who else lives in the home? Where does Renora live?
Renora lives in the home with the grandparents.
Okay. And is there any issues with the home in terms of the physicality of the home, Ms. Sullivan?
I have only entered that home on one occasion, and I had only stepped in the living room. As far as that went, no, there were no concerns.
Okay. And in terms of the grandfather, did you look up his history?
I did.
And did you determine if he has any child abuse history?
Actually, I take that back. I did not have to look at his history because he was not a perpetrator.
Okay.
So I did not look at his history.
Okay. And in terms of the force itself that the grandmother used, you made a determination that it wasn't serious physical harm, correct?
I guess I would say that it was serious enough that it left marks and bruises. I wouldn't say severe, but I would say serious.
Okay. If it were a serious, wouldn't you have to file a petition to terminate Renora's parental rights?
She was not substantiated on the physical harm.
Who wasn't substantiated on the physical harm?
Renora was not substantiated for the physical harm.
So is she a failure to protect? I'm trying to figure that out. Is she a failure to protect? Is that what she is?
We don't use that term anymore. Now it
Sorry.
is placing a child at unreasonable risk, but essentially it is one and the same. It's just different wording.
Okay, it's confusing. Thank you for explaining that to me. So you guys changed that to be threatened. Okay, I won't ask you why. That's irrelevant. Okay, so in terms of that placing the child at risk of harm, you wouldn't file a petition against her because she didn't do that to the kids, correct?
I'm sorry, you're referring for
Renora
termination.
didn't do that to the kids, correct?
But you're speaking in regards to a petition for termination? Is that what you're? Yes, correct.
Okay.
You are correct.
Yes. And so Renora, actually, there's nothing about her that you've ever found out that said that she would physically abuse her children, correct?
Correct.
Okay. Now moving on, I just want to ask you another question in terms of the safety plan itself. Oh, about the pictures, I wanted to ask you, did anybody do a forensic audit of the fathers of these pictures? And in other words, did you have an expert look at these pictures?
I did not.
Okay. Did the police
Ms. Cannon,
Yeah.
Cannon,
Yes.
I've been, I believe, somewhat lenient in allowing you to do a whole lot of discovery today. When are we going to get to something that has to do with your motion to change placement? Right now, we're talking about all of the things that would normally happen at an adjudication trial. I haven't heard anything, or at least I haven't figured out where you're going with anything that has to do with change of placement.
Let me get right to it.
Thank you.
You had a safety plan in October of 2025, Ms. Sullivan?
Yes.
Okay, and that safety plan was that the mother should not be alone with the children, correct? The maternal grandmother.
Correct.
And what did you make a determination? Did you conclude that the safety plan was, and was there any other safety plan in October of 2025?
Essentially, the bulk of the safety plan would be that Renora would not leave the children home alone with her mother.
Did you end up filing a petition because you believe the safety plan was broken?
Correct. Yes.
Okay. And I'm getting to it, Judge, because I'm trying to figure out, what was it exactly that you thought she broke the safety plan? Why did you think she broke it?
So on the date that we did the forensic interviews of the children, Renora had an anxiety attack in the lobby of the CAC Center. When the victim's advocate came to Renora and asked her what was going on, she said that she had lied to myself and to MSP about following the safety plan. I contacted the babysitter that she told me would be watching the kids, and there were no plans for that particular babysitter to babysit the kids that evening. And I knew that Renora had to go to work that day. So essentially and I had talked to the babysitter about how often she was babysitting and those types of things. So it was determined through Renora admitted that she had lied to me and to MSP about leaving the children with her mother and the babysitter that Renora had appointed to watch the kids.
Okay. Now, are you sure that's what that lady said?
This short exchange explains why authorities finally decided they couldn't stay on the sidelines anymore. A single statement reframes months of events and gives insight into why action was taken when it was, rather than earlier.
That she lied to her?
Yes, she
Okay.
came immediately into the room after her encounter with Renora and reported that.
Did she tell you when she was leaving the kids with the grandmother?
She did not.
Okay. So essentially this is what caused you to file the petition, correct?
That the disclosures by the children and then the MSP interview with both Gail and Renora.
Okay. And I'm going to move. I have questions about that, but I'm sort of going to ask you this. You are required to make reasonable efforts. Did you refer Renora for any services during this October of 2025 investigation?
I did not refer her to any services at that point because I was still fresh into the investigation. We were only 2 weeks into the investigation, or 9 days into the investigation at the point that I filed the petition.
Do you guys use any sort of in-home services?
We do, and she had completed 2 separate programs prior to this investigation.
But those
She had-
programs didn't address the exact issue that you were concerned about, which was the May of 2025 physical discipline by the grandmother, correct?
Correct.
Okay. So is there like something that says that you couldn't have had them in there again?
Judge, I would object here, Judge. Miss Lee's prior counsel waived probable cause at the preliminary hearing. The issues of 3.965B and C, the 5 questions, all of those determinations were waived. In our petition, we talk specifically about the reasons why removal was necessary, where in our petition we allege the elements of 3.965C2 and all of those questions and the reason why. These questions, I mean, in one sense, Ms. Cannon is kind of stuck with the prior counsel's waiver of probable cause, and we're kind of revisiting something that was previously waived.
Ms.
Your
Cannon,
Honor,
response?
let me try to rephrase the question because I do want to get done and I want to get the questions that are important done. So if I could just try to rephrase it, and then if he objects again, I can respond. I think that my ultimate question, if I could just rephrase it to ask her, is that service something that she could employ now?
Go ahead and ask your question rephrased.
Ms. Sullivan, I understand that you might not want to, but is there anything precluding the department from offering an in-home service right now?
Yes, the in-home services aren't available if the children are not residing in the home.
But if the court, and I'm not saying the court will, but I'm just saying if the children were residing in the home, is that a service you could provide again?
I could make a referral, but I don't know how soon they would start.
Yeah, I understand that and I get that. So Ms. Sullivan, so you could make a referral. What other services would you recommend? I mean, you're not suggesting that Renora needs to not live with her parents anymore, are you?
At this point, no. That she does depend on them financially for majority of her daily living stuff. So
what would these people need to do to make you feel safe about the children? What services would they need to do?
well, primarily, first and foremost, psychological evaluations would have to be completed. And then we would make recommendations based upon the results of those evaluations.
So you couldn't recommend that they don't use physical discipline?
That would be more of a safety plan than a service.
Okay. And did you make any referrals to Renora? I know she doesn't have to participate in them, but have you referred her for counseling for anything like that?
I have not made referrals. I have asked Renora about completing a psychological evaluation, and at this time, um, that, and you weren't her attorney at the time, but at that time, her attorney was not recommending that she complete that service.
Okay. So I guess related to what would be the substantial risk of harm to the children right now, from having the children in the home with some sort of in-home services with this family? What would be the risk of harm to these kids today?
I would say they would continue to be at a substantial risk of harm. During the ongoing CPS case that I've had, there's been a lot of concern about mental health. There's been concern about mental injury to the children while they were in her care. They are still residing with the grandparents, and there's been no services to rectify the situation that led the children to come into care.
That's what I'm getting at. The psychological exam is not going to prevent anyone from hitting these kids. Wouldn't you agree?
I would agree with that, but it would make a determination as to what services could be provided.
Okay, so what about parenting class, beyond parenting classes, and what other services would you think that she would need?
I do believe that she needs some substantial counseling services. And I think that the type of counseling services would be at the recommendation of a psychological evaluation. I would want to ensure that she's receiving the proper services.
Okay. So, essentially, you feel that these children are at risk of harm because the grandmother used spoons on them for discipline, and Miss Lee didn't think that that was abuse. Am I correct?
As accusations pile up, certainty becomes harder to find. You can hear how easily allegations can shape perception even when proof remains thin, and the court is left weighing credibility against consistency in a situation with no easy answers.
I don't know that she didn't think, I don't know what she thought about that as far as whether or not it was abuse.
Okay. Finally, I want to ask you about, you have had an opinion for a while now that Miss Lee exaggerates allegations related to Mr. Lee, correct?
I wouldn't say that's necessarily my opinion. I would say that she makes a lot of allegations against Mr. Lee, whether they're exaggerated or not, I don't know, but I would say that she does make a lot of allegations against him.
Okay. And in your petition, you sort of took exception to the fact that the friend of the court had Mr. Lee on supervised visitations. You specifically say that even though you made no findings that about Mr. Lee, she continued to file with FOC. Is there a reason that you think that's significant, what she does in FOC?
I mean, I guess what happens with the friend of the court, I don't have any involvement in, essentially, unless I'm subpoenaed to a hearing. As far as the supervised visitation that was ordered for Mr. Lee, that was based upon a domestic violence incident that was reported to the police. And if you actually read the police report, she was listed as the perpetrator and he was listed as the victim. And she submitted that report before it was complete. And he was still listed as the perpetrator and she was listed as the victim.
Okay, so you feel that that's sort of, she misrepresented to the court and that's how she got her order, her custody order. Is that how you feel about that?
Yes.
Okay. And you agree that, were you aware that after your January, there was a referral for sexual abuse about Mr. Lee, and do you remember that Miss Lee challenged your finding about saying that the sexual abuse didn't happen?
I'm sorry, I guess I don't understand what you're asking.
Were you aware of the grievance that she filed on you in early 2025?
Yes, I was.
Okay. And so by the time and her grievance against you was that she didn't agree with the fact that you didn't substantiate the sexual abuse, correct?
That is correct.
Okay. And in terms of Mr. Lee, when he actually got charged with CSC third degree. Do you agree?
He was not convicted of a CSC third. That was the original charge, but that was not what he was actually convicted of.
Okay. What was he convicted of?
2 counts of domestic violence.
And did you write a support letter for Mr. Lee?
I did.
Okay. And what did you say in the support letter?
I essentially stated that the children were just placed into his care, that they were going through a transitional period in his care, and that I thought that should be taken into consideration before sentencing.
And you also told the sentencing judge that there was a petition filed on Miss Lee, correct?
Correct.
Okay. Are you aware of a PPO in this case?
Yes.
Okay. And the PPO is against Mr. Lee to protect Miss Lee, correct?
Correct.
Do you feel the same way about the PPO that you sort of feel about the custody case, that, you know, she's getting these things by manufacturing information?
I don't know all of the reasons for the filing of the PPO. I know part of that was due to that domestic violence incident, but I don't know what all of it entailed.
Okay. Do you feel that Mr. Lee has sort of been treated unfairly because of Miss Lee?
I honestly don't know how to answer that. I feel like he's been misrepresented.
Okay. Finally, do you allow Mr. Lee to be at the visits around Miss Lee when you have them?
No, he drops the kids off to the visit and then he comes back and picks them up.
Okay. And also, do you I had like, Your Honor, just give me 20 seconds or 10 seconds. Hold on 1 second, Your Honor. So in terms of services right now, other than a psychological evaluation, if by some chance the court decided, oh, let me ask you this, is there a reason why you can't utilize the grandfather to either have to supervise, you supervise the visits, correct?
I do.
Okay, is there a reason why you can't use the grandfather to supervise the visits or to be the person involved in having the placement of the children?
My response to that would be the way the court order reads is that parenting time is supervised by the department or their designee, and I have not designated anybody other than myself to supervise parenting time visits, or other than the department to supervise parenting time.
And do
I can't
you
say
ever,
just myself.
yeah, do the kids have good visits with their mom?
Visits sometimes go very well. Visits sometimes go very bad.
Okay. Uh-huh.
There's a lot to the visits, considering that there's 4 children and they are all vying for mom's time and she's one person. So at this juncture, I truly feel as though it's in the best interest of everybody for the department to continue to supervise the parenting time visits and not assign a designee.
So what you're saying is the kids miss their mom, correct?
They do, yes.
Okay.
That's
Yeah, and that the how long are the visits?
2 hours.
And what are the range of the age of these children?
5, 4, 3, 2.
Okay. And so you can so they at that age they probably really miss their mom. Am I correct, Ms. Sullivan?
Yes, they do.
And how do you think, you think that a limited 2-hour period is sufficient time at this point based on this petition?
The focus shifts again as the judge looks beyond emotion and starts weighing stability over reaction. This moment shows how courts often think in terms of long-term impact, even when one side is clearly frustrated by the present situation.
Judge, let me object. I mean, again, I don't think we've gotten any closer to the relevant questions that the court directed counsel to ask. This has nothing to do with changing placement. We're talking about expanding supervised parenting time, having a different supervisor. So I would just ask the court to remind counsel as to why we're here today.
Judge,
Ms.
if I
Cannon?
may respond, I don't necessarily think, I could bring that up at any hearing, at any pretrial settlement hearing. I understand that it's not specifically cited in the court order, but I think it's a consideration for the court here today. And if we're here, I think this is probably a relevant question at any hearing. And that's all I really wanted to ask her about, how old the kids were and how and what the visitation is. I think that's very relevant in this case.
Ms. Cannon, I've asked you previously to get to the issue of whether or not the kids should be changed in their placement. So far, I've had a few questions about reasonable efforts, and everything else in my mind seems to be peripheral. Please direct me to where you're going with this, or move on.
Okay. So, Ms. Sullivan, do you think it's contrary to welfare for the children to be placed with Miss Lee?
I do.
Okay. And do you think that she poses a
for 2 hours? The other parent ought to have the ability to watch the child. If their allegation is true that she's working till 7 or 8 at night, okay, whatever, then he can have his parenting time. But my client's available to watch the child, and there's no reason for his girlfriend to be having the parenting time until we get to trial. She's been living under this problem since September of this year, when he unilaterally just started enforcing the parenting time agreement. So we've been waiting since November to get a ruling from the court. There's no reason for the child to be with the girlfriend when the child can be with the mother. And so we would like, on a temporary basis, or at least until the trial, for the court to allow the mother to have the parenting time that the father's not exercising.
Your response to this temporary parenting plan, Mr. Thompson?
Your Honor, I do not believe that it is in the best interest of the kid or the child or appropriate, Your Honor. We have discovery when Mr. Hawley argues that, well, they claim she gets off, she doesn't, she has to work until 7 or 8. We're not claiming it. That's in their discovery responses. I read the exact discovery response, Your Honor. That is from the sworn interrogatory responses we received Friday afternoon, Your Honor. We're not making it up. So she is not there all the time for the child either. We have working parents, Your Honor, trying to, well, what Mr. Hawley's asking for is a modification of parenting plan based upon a standard or Zoom motion without the benefit of evidence or due process, Your Honor. That's inappropriate. There are factual disputes in place. It sounds like we have either inconsistent discovery responses with Mr. Hawley's argument, or there is something amiss here about her work schedule. I don't know what's so secret about it. They said she gets off work at 11:30 to 7:30. That was the extent of their response for that time. She also mentioned the getting off work at 5, Your Honor. Both parties are not going to be with the child the whole time. There's no reason to upset this parenting plan on a Zoom hearing without the benefit of evidence, Your Honor. And the court pointed out, we never got a direct answer for it, that if Ms. Ross was concerned about these issues, she had until from January of 2024 until she filed her motion in November of 25 to file a motion to adopt whatever she thought the status quo was. She did not do that. She waited until months after shared parenting time started to file her motion. The court asked that question, never got a direct answer to it. I brought it up in one of my arguments here. So right now we're trying to push this without the benefit of evidence, Your Honor. And it appears to be a money issue. We got a child support worksheet. She wants to get a significant amount of child support, Your Honor. I think that's why we're pushing it instead of waiting until, it's just until April, Your Honor. We have a very expedited, it seems to me an expedited hearing setting, which is fine. The court is not putting this out until July or August. We're having it in April in a couple months, Your Honor. So it's not a significant period of time. And the parties have already been doing this from September. And keep in mind, mom waited 2 months to file her motion from September, even though she had a year and a half prior to file a motion. So there's no reason to adopt a temporary order modifying Joyce Demo's, the parenting plan that was adopted by the court.
Judge, this is ridiculous. He started working second shift and stopped exercising his Wednesdays and Thursdays. If the mom wanted money, she should have filed it back in 2024 when he stopped exercising, but she didn't because everything was fine. She didn't care about the money. She just wanted the parenting time. And then in September, when he unilaterally said, no, my girlfriend's going to start watching the kid. Well, he wouldn't even tell her who was watching to begin with. Then she came and got me, and we filed a motion to change custody. And the only reason we've waited so long is because we couldn't get into court until now.
And Your Honor, this was not a unilateral decision. My client, there's another evidentiary issue, said there was an agreement with the parties. Get the relationship with Josie established, that happened. Then the shared parenting time resumed. And then she filed her motion after that's been going on a couple, 3 months.
Why would she have filed her
Counsel,
motion?
we go back and forth endlessly here. The court's prepared to rule on Mr. Hawley's request. Mr. Hawley, I understand the reasoning behind your request today, but the court's going to deny it essentially for two reasons. Number one, and I understand that you've acknowledged that you made a mistake on this representation earlier, Mr. Hawley, and I fully accept it. But your client is not a stay-at-home mother. She herself has significant times during the evening that she herself is not available to spend time with Emma. That's certainly one consideration for the court. If she were indeed a stay-at-home mom, the court very well may view this issue differently. But there's another reason why the court's going to deny the request is that there is an established plan that's in place for this school year. Commencing with September, a new schedule has been established. Emma is used to that schedule, and there's been no showing that it is contrary to her best interest at this time to continue, at least temporarily, the plan which is currently in place. It's at least consistent with what appears to be the schedule that Emma is currently following. And I understand that the court is concerned that the father is not there to spend evening parenting time, but there's also been no showing that Emma has been materially compromised by the plan that the father has put in place for substitute care at this time. We need to sort this out. And I think it's going to take an evidentiary hearing development to sort it out. So the temporary request is denied. The current de facto plan, which is essentially the court-ordered plan, remains in place pending the evidentiary hearing which the court has established.
Your Honor, who would you like to draft the order?
You, Mr. Thompson.
Thank you, Your Honor.
You can get that circulated with Mr. Hawley as soon as possible, setting forth the rulings and dates and deadlines which have been established by the court here today.
Yes, Your Honor. Thank you.
In the end, the judge draws a firm line and keeps the current arrangement in place, signaling that bigger decisions require deeper evidence. If this breakdown helped you see the layers behind the ruling, like the video, subscribe to the channel, and we'll see you in the next one. Do you agree with keeping things the same until a full hearing happens?